Hello, good afternoon, and thanks to everybody for joining. This is Bart Walker. I'm a partner with McGuire Woods and Healthcare Group. Thanks again for joining. The title of today's presentation is Dermatology Transactions, and we're hoping to walk you through some of the key legal and M&A trends here today. We've got a great guest speaker today, Clint Bundy, who's Managing Director at the Bundy Group. Kayla McCann-Marty is with me as well, who's an associate in the Healthcare Group here in Charlotte with me. If you're not familiar with our firm, McGuire Woods is a firm of 1,000 lawyers. We're the sixth biggest healthcare practice in the country, with a specific emphasis on the intersection of healthcare, private equity, and debt finance. We're organized around some key verticals in the healthcare space, of which dermatology is one. We also do a significant amount of work in surgery centers, dialysis and nephrology, dental, pain management, behavioral health, kind of the flavors of the month in the PE world, and also we're privileged to do quite a bit of work for a lot of the large private equity funds and lenders in the space. Before we get started, here's just a very brief sampling of some of the derm transactions we've worked on, and this really just includes the ones that involve a sponsor at some level. This doesn't include the strategic M&A, which is a little bit different ball game. So just to give you a flavor of some of the things we've worked on. We find that's usually helpful just to orient yourself kind of where we are in the market. We're squarely in the middle market of healthcare services M&A. One quick housekeeping note, I know there is Q&A functionality on this webinar, so if you do have questions, feel free to enter them in. We'll try to answer those as they come throughout. We've got plenty of material, and hopefully this is informational for everybody. I think we can make it even better if we have input from you and we can answer your specific questions. That's usually a better approach in our experience. So with that, I'll just go ahead and turn it right over to Clint. And Clint, if you could just tell us a little bit about your firm and then go ahead and run with it.
Sure. And Bart and Kayla, thank you again for hosting me here today. I'm excited to be a part of the conversation. First, our firm, Bundy Group, is a 30-year-old boutique investment bank. We specialize in representing business and practice owners in business sales, capital raises, and acquisitions. Offices in Charlotte, North Carolina, and Roanoke, Virginia, but we work nationally and internationally. So that's just a little bit about us. And dermatology is one of our key focus areas, much like Bart and Kayla. Well, let's kind of jump right into it if we can. And what I want to do is give an overview today of what's driving the M&A activity in the dermatology space. But before I sort of get into the trends and what have you, I want to start out with the general theme of the activity in the dermatology space that's occurred over the past, call it 6 to 7 years. And it's really kind of a tidal wave of M&A activity in this space. Has been driven by private equity groups. And just so we're all kind of comparing apples to apples, let's kind of define what a private equity group is, which is a fund of money that is managed by finance and operating professionals. Typically, these funds are receiving money from pension funds, high net worth individuals, university endowments, to invest or acquire a majority equity interest in privately held companies. And I said majority, but usually they are not acquiring 100%, because oftentimes they're leaving the existing shareholders or physicians with a minority equity stake in the company after transaction close. And their goal as a private equity group is not to come in and operate a practice, but instead to find ways to partner with the physician or the physicians to grow the practice and financial performance over a period of time. And so ways of growth, and there are numerous ways that they're going to look to grow, but in essence what a private equity group wants to do is take their investment and substantially increase it and then resell the company in the future. And ways of stimulating that growth are opening new locations, adding new physicians, adding new service areas such as Mohs or a lab or cosmetic services. And then a very common playbook for private equity groups is once they complete their what we call platform or initial investment into the sector, the dermatology sector to be specific, they want to turn around and go complete what we like to call add-on or tuck-in acquisitions. So just to give an example, it could be a private equity group invests in a 20-provider practice in a certain region of the United States, and then they turn around and go buy a number of 1, 2, or 3 provider practices or larger that are within a similar or contiguous region. And the goal being is that they want to acquire and combine these smaller practices with their platform to get combination benefits. We use kind of the fancy word as synergies, which I think we all here around the table are familiar with. And the synergies could end up would effectively drive a higher profit for the combined entity when you put these 2 or 3 or 4 practices together. And examples of synergies could be higher reimbursement rates, better negotiating leverage with payers. It could be more cross-selling of services between cosmetic modes and various locations. And it could be better and more efficient sharing of administrative resources, all with the end goal of driving up the profitability and the EBITDA of the combined entity, and driving up the EBITDA then therefore increases the value of the overall company. The goal of a private equity group is ultimately that they want to get back, when they resell their dermatology investment, they want to get back anywhere from just a ballpark range of 2 to 5 times of the equity that they have initially put into an investment. So as an example, if a private equity group places $10 million of equity into a dermatology transaction, when they get back out of that investment and they call it 3 to 7 year period, they're going to hope to get anywhere from kind of $20 to $50 million back on that equity investment. And that's just a general rule of thumb. That's not hard and fast. So hopefully that gives sort of a good overview of sort of private equity again, so we're all on the same starting block.
Hey, Clint, what's the average investment time for a private equity fund from the time they purchase the platform versus once they ultimately sell it?
If you were to look at the average, and normally when we were talking with potential clients about the private equity option, we say plan on 3 to 5 years. 7 years, I think, for a lot of private equity groups, it can happen, but it's getting a little long in the tooth. Mm-hmm. Now, just to tie in the concept of what's called the family office, which you all may be familiar with that, where you have effectively high net worth families who are investing direct in the companies themselves in a fund-like format, but they're really the only capital provider, the family is. Those investments you see going longer often than 5 years. I'd say the average on those can go more like 5 to 10 years.
Okay.
So if that, it's a good question. Now that we have kind of an explanation about private equity, let's talk a little bit about what's actually going on in the market today with M&A in the dermatology space. And at a high level, I'd say, first of all, the demand from private equity groups for purchasing or investing in dermatology, whether it be platforms or add-ons, is actually outpacing the supply today of potential sellers. Now, I do think that's changing as time goes on and physicians are becoming more and more educated about the private equity route, but I hear this frequently from dermatologists that they're getting calls left and right from various private equity groups expressing interest in having conversations with them about potentially a sale. In 2011, just to give you some statistics here, there was one private equity group active in the dermatology space. In 2018, we now have over 30 private equity groups active in the dermatology sector. Year to date through July 8, 2018, there have been 35 transactions in the dermatology sector, and that's, which I think indicates a pretty robust amount of activity in the space. Let me just give a few examples of transactions that have occurred. Greif Investors, a $4 billion private equity fund, acquired Water's Edge Dermatology, which is a 30-location dermatology practice in Florida. Anne Arundel Dermatology, which is a portfolio company of New York-based New Mainstream Capital, acquired actually two different dermatology businesses in Tennessee, Dermatology Associates of Knoxville and East Tennessee Dermatology, which extended Anne Arundel's footprint from kind of the Mid-Atlantic Maryland area further into the Southeast. Ontario Teachers Pension Plan, which is a $175 billion fund based out of Canada, acquired Northeast Dermatology Associates, which is a 15-location dermatology practice in Maine, New Hampshire, and Massachusetts. And just a couple other, we could go on all day here, so I won't do that to everyone, but a couple of other examples. Pinnacle Dermatology, last count, has completed 6 deals in 2018, and they are backed by a private equity group out of Chicago. U.S. Dermatology, which is backed by Avery, has by last count completed 8 add-on acquisitions in 2018. So again, a lot of activity that's occurring in the market. Let me kind of transition over to why is it that private equity is kind of rushing into the dermatology space. And I think, again, we could do a whole webinar on this topic alone, so I will hit some just high-level points. First, private equity groups are very savvy investors, and they're very good about finding markets that have scale and growth, both past and projected growth in the future. Dermatology is a $16 billion market. It's expected to grow at a 2.3% compounded annual growth rate through 2021. And so it just kind of checks all the natural boxes for private equity investors as they look at the market opportunity. Second reason I would say is that it's what I would call a durable market. Private equity groups, at the end of the day, while they understand risk as part of investing, they are risk averse if they have those druthers, and so they're going to gravitate towards what I would call recession resilient industries. I don't know that there are too many recession proof industries, but they do think in terms of recession resiliency. And just to give a data point, from 2009 to 2012, during the depth of the financial recession, dermatology still grew at about a 2% rate. So pretty impressive when a lot of other industries and companies in other industries were suffering mightily. Part of the reason it's a durable market is that, as a lot of people on the phone probably know, is that the multiple service lines that dermatology offer kind of help to offset each other during challenging times. So you've got Mohs surgery, medical dermatology, cosmetic. They all provide diversification to a practice and ultimately to an investor. So as an example, if during a recession, one service line such as cosmetic services shrinks, then the other service lines such as medical dermatology can pick up that slack, for lack of a better term. And then a third reason is what I would call the consolidation opportunity that exists within the dermatology space. There are approximately 11,000 practices in the United States today, with approximately 1/3 of those being owned by solo practitioners. So as private equity groups make their platform investments and then they turn around and look for add-ons, there's a healthy market and a healthy mass of opportunities where they can go complete their add-ons and gain their efficiencies or synergies, as we talked about earlier. So this is why I think you're seeing in the market today that the smaller kind of 1, 2, 3 physician practices are getting called almost as frequently as the larger 7, 10, 15 provider practices. So just as one other side comment on where are we with sort of the trends in the market, I was on a panel at the American Academy of Dermatology conference last year, and the moderator asked all the panelists, well, if we were in a 9-inning game, what inning are we in on this consolidation trend? And everybody on the panel agreed we're probably maybe at the beginning to middle part of the first inning. So still very early in this consolidation cycle. And again, many other reasons can be listed for why we are seeing private equity groups invest in the space. And then here on kind of my fourth bullet and kind of final area is, why are the dermatologists considering private equity as a viable route? And prior to this sort of private equity emergence, and certainly Bart and Kayla can offer their insights, but I think the logical, often buyer play or exit option play, if you weren't going to sell internally to other physicians in your practice, was going to sell potentially to a healthcare system, which that still does occur occasionally in the market. But relative to, say, selling to a healthcare system, a dermatologist can sell to a private equity group. Private equity groups today are often paying very attractive all-cash valuations. They're giving dermatologists the ability to retain some equity to get what we like to call a second bite of the apple. And traditionally, a private equity group does not look to come in and make any massive changes to the operations. So that can often sit well with the dermatologists. So I think that's a major reason why hey, this is a new avenue on the private equity side, and it's a legitimate avenue for myself if I'm a physician thinking of a sale or an exit to consider. A few other reasons for why practice owners are considering more aggressively considering a sale, and specifically to private equity groups, is the regulatory environment continues to increase, and the entrepreneur physician or the independent physician group often bears kind of the administrative and resource draining brunt of these regulations. So just to give again another kind of fact, on a survey that was done in 2011, the burnout rate among derms was around 31%. By 2014, that had moved up to about 57%. And a major reason stated in the survey was because of the administrative kind of burdens put on the doctors. And a buyer who understands how to set up an operating structure can help to come in and set up a framework to alleviate the headaches of administrative requirements, which kind of moves into the next one, which is the focus on the patients. Again, as the doctor removes some of the business and administrative responsibilities off his plate through a sale, that in turn allows them to focus on the patient, which then allows them to focus on revenue generation, which ultimately benefits both the investor as well as the doctor, whether the doctor has retained some equity in the business or is paid off of a percentage of collections. And then finally, I'd say just their overall, as a selling physician, their personal financial goals. And if you're a selling physician and you can get a nice all cash or mostly cash offer from a buyer in what is a high in demand market today in terms of dermatology, then they can fill out or largely fill out their retirement nest egg. They can get a nice employment agreement in place where they can be paid a percentage of collections, often an attractive percentage of collections based off what they generate in the future. And as stated earlier, they may have the ability to retain some equity and get that second bite of the apple when a private equity group resells in the future. So again, these are not all of the reasons why a dermatologist considers a sale and or a sale to a private equity group, but it's just some of them. So,
Clint, one follow-up question. We hear a lot about, at least in our day-to-day, about other physicians of other specialties being hired away by hospitals and hospitals buying practices. We don't tend to see that as much in the derm space. Have you seen much of that at all?
On a limited basis relative to other industries. There was a transaction that occurred up in Virginia recently, Carillion Healthcare, which is in Southwest Virginia, just acquired a dermatology practice out of Roanoke, Virginia. But relative to other industries, we don't see it as often,
sure,
to answer your question. But it's still a viable route.
Sure.
But it's, what we feel like is that maybe even more so than the healthcare systems that were acquiring practices before this kind of emergence of private equity, what you're probably seeing is more regional consolidation occurring with the dermatologist down the street who may be younger and he can come in and buy out my practice, and that still occurs too. But that maybe have been more of the primary exit option for a selling physician, or of course the internal sales partners who are there. So, but that's sort of, and I hope I haven't monopolized too much time here, but that's sort of at a high level some of the key things I just wanted to address on the market.
Sure. And before we can switch to our part, could you talk to us for a minute about valuations, kind of where you see them and where you see them heading? I know that's a very tricky topic and a very complicated topic. Do you generally see valuations as frothy? Are they priced right? Are they going up or going down? Kind of what are some observations on that front?
Yeah, that's a good question, and that's certainly kind of an 800-pound gorilla in the room kind of question that's always good, I think, to address on these calls. I'm happy to give my thoughts on it, which is I will tell any physician who may be considering or is considering a sale is that ultimately valuation is going to be driven by the market. It's going to be driven by competitiveness of a process that they encounter, i.e. how many buyers want to acquire the practice and how many buyers are they focused on trying to involve in their process to bid or submit what we call a letter of intent for a practice. But what I tell you at a very high level is that first, the valuation of a dermatology practice is based off of what we call a multiple of adjusted EBITDA. And I'll just define real quickly adjusted EBITDA, which adjusted EBITDA is, if you want to take your P&L statement, take your net income, add back income taxes, depreciation expense, amortization expense, interest expense. Adjusted specifically refers to non-recurring expenses that could occur in the practice in a given year that aren't going to occur on a continual basis. You can add that expense back. Other extraordinary expenses that a practice owner may be paying that a new owner wouldn't pay. For instance, if the country club dues are being paid out of the dermatology practice, probably a new owner is not going to pay that. So you can add that expense back. But the real kind of big one we find in the dermatology space is what we like to call excess physician owners' compensation. And so most physician owners are paying themselves, usually they're paying themselves a compensation amount that is above and beyond what they would be paid if they were a physician under a new ownership structure. And so what you'll do in that adjusted EBITDA calculation is you will take that difference between what they're paying themselves today as the 100% owner and what the physician would make under a new ownership structure. You would add back that difference. And that can often be, in Bart, you may see this in deals you work on, but that can be a pretty significant amount, which can really boost the value of the practice, and i.e. the amount of cash that they're going to receive at close on a deal. So what we do is take that adjusted EBITDA. It's also possible to layer in the value of some synergies, which this is where the value of talking more to one buyer can come into play. But you can layer in the value of the synergies too and add those into your adjusted EBITDA calculation. And then you're going to apply some kind of multiple to that. And the multiple ranges, and this is, it's a question that is very specific to the practice, the location, the fundamentals of the practice, the profitability. But what I can say today observationally is that you're seeing some transactions go as high as 10 times adjusted EBITDA and beyond in this market today, and really going significantly higher than 10 times. So that's kind of the best guidance. Hopefully I've answered your question.
Yeah, absolutely. And so using simple lawyer math, let's say a practice is throwing off $1.2 million a year pre-transaction. Going forward, you pro forma that out, and let's say the physician will make $200,000 a year just on a salary basis. What you're doing is you're creating EBITDA of $1 million, applying a 10 multiple of that, and that turns into a $10 million transaction. and hopefully you get capital gains treatment on that instead of ordinary income, so there could be some tax advantage to that as well.
Yes, agree with everything you said. The only thing I'd add to that is that you may have some other add-backs in addition
Sure.
to what you've just referenced, but your math and
Sure.
the way you look at it is absolutely 100% spot on.
And absolutely a gross oversimplification of all the Excel-based magic that you guys do every day, which I don't pretend to understand. So we'll certainly leave that at the Excel.
Not often my job gets referred to as magic.
to lawyers, it is. Well, at any rate, so let's transition just very briefly over to market conditions from our perspective. We'll give you a few thoughts on that. I can talk a little bit about structure just so we're on the same page. And I fully appreciate we've got a range of experience dialed in. I know on the attendee list we've got over 100 people dialed in, and some from PE shops, some from companies, some who are solo or small groups. So I appreciate there's a range of experiences there. So wanted to just set some baselines so that everybody's coming from the same position. In terms of market conditions and how we segment the market, I think Clint's already talked about this a little bit. In terms of, you've got the large consolidators, of which there are few. You have a number of medium or regional operators, and then kind of everybody else is deconsolidated, smaller practice settings. Like Clint said, we're seeing a shift towards MSO-supported practices. And before I use too much terminology on you, so an MSO is a management services organization. And what that refers to is a structure we'll get to in a few slides. But in most states, you cannot own, in the traditional sense, a physician practice. So unless you're a licensed physician, you cannot own and operate a physician practice. The policy reason for that is you don't want unlicensed individuals controlling the practice of a licensed individual who's gone to school, received training, passed exams, and is ultimately responsible for patient care. And so the closest you can really get to that is being able to control and operate the business side of the house on behalf of the licensed professional. And that's a line you have to police very closely. So MSO just stands for Management Services Organization, just to give you that context. And of course, we've seen a ton of private equity involvement and interest in the sector. I always start this. I added the slide to our presentation just a couple months ago because we spend a lot of free time on the phone with people, just helping them formulate ideas and try to decide whether or not their approach is right and what everybody in the market is doing kind of generally and how things are typically put together. And we often get calls with people asking to put in place this MSO type structure or this MSO creation. And there are some very specific reasons why you want to do that. There are other reasons that are not so good to do it. And so I'd like to just preface the conversation by saying that there are some good reasons to form an MSO, not so good reasons. So the reason people really go towards this structure, which again we'll get to in just a minute with a diagram to help really help people visualize what I'm talking about. Scalable standardization of processes, synergy, some of the things Clint talked about earlier, efficiencies of scale. It allows you to aggregate. Those are also things that you can accomplish just within a regular practice environment. So if you wanted to maintain 100% physician ownership, you can do that in that model as well. Professional business management, you get to a certain scale, and it's difficult to really attract top management talent without some sort of equity incentive. It becomes difficult to grow using only debt at a certain point. So that's kind of one of the reasons is the capital structure and the ability to attract professional business management. Non-physician ownership of the MSO, again, non-physicians really can't own, in most states, now this is a state-by-state issue, but in most states you really can't own directly in the practice, so that's another big driving reason to form an MSO. If you want to expand into multiple states, it allows you to have a consistent management structure and administration structure without having just a single monolithic practice entity. So that's something to consider. And then segregation of historical liabilities. If you're going to have multiple practices that are affiliating under common management, that allows you to keep them as separate silos, so to speak, with different legal entities. Reasons not to form an MSO, it really doesn't create any value in and of itself. You really have to take advantage of the business opportunities. The structure itself doesn't really do anything magical. Another downside is front-loaded costs. As much as I enjoy my job and enjoy working on these structures, if you're not going to get any benefit out of it, I really don't feel the need to do the work. Same thing with accounting fees and financial advisor fees. If you don't need to do it, it may not be justified by the front-loaded costs. Additional structural complexity, instead of having just one single legal entity, you have a couple. That requires some education for both your physician owners as well as employed physicians. It can create some complexity around employee benefits and who can participate in what plans, and ERISA issues as well. It also can decrease the flexibility for future reorganization. Once you start to move assets around, you start to do things like restart depreciation schedules. You can trigger tax on built-in gain. There are some, you can restart holding periods for capital gains treatment. There's a number of things that you can do that just reduces your overall flexibility going forward.
And Bart, question here. We have a lot of people that come to us and have the impression that in order to do a sale, you have to have an MSO. What has been your experience with that? I think we have some varying degrees of views on it.
Great point. So there are plenty of deals we do where we transact out of just a single practice entity. You really don't have to pre-structure any of this. You can do basically the same things at a moment in time prior to closing that you could with pre-structuring the whole thing. So that's something to think about. And then you've got the ongoing maintenance costs of the entities, which may or may not make sense. That's going to be some added cost. And then corporate practice, which we'll talk about in a minute here. Here's the basic structure. This is just a very brief overview of what we'll cover quickly. I want to make sure I leave time for questions and leave time for Kayla too. The corporate practice of medicine, again, we already talked about, only licensed physicians can own a practice in most states, and that's really what drives the ownership structure here. There are also state-level issues, federal laws that you have to obey in putting these things together, which can be complicated questions. Here's the basic structure, and again, you really are building a wall between the clinical aspects of the business on the PC side, which is a professional corporation, or in some states it can be a professional limited liability company. And then on the left, you've got the MSO, which again is just a management structure. The management entity can be owned by anybody. That includes the physician owners, it includes non-physicians, but the big link between the two companies is the management services agreement. And that is where we spend a lot of time on a state-by-state basis trying to craft that in a way that complies with state corporate practice restrictions. It is critically important that that agreement does not exercise too much control over the PC. The management entity really needs to stay on its side of the fence, and the practice needs to be controlled by the physician owners. That's going to be true regardless of what state you're in. So even in states where you've got direct ownership allowed, the medical decision-making still has to be done by licensed physicians. Here's an acquisition structure, and again, this can get much more complicated than this, but this is just a very basic way of doing a stock transaction. We usually don't see stock deals in this context. It's mostly moving assets around, and that's on the next slide. So here, typically we would see non-clinical assets being sold to the MSO, then the clinical assets either staying in the target PC if that's going to be the practice entity going forward, or being transferred to an acquiring PC. That can either be newly formed or an existing platform PC. And then you put in place this management services agreement between the two. Again, this is a gross oversimplification, but we'll at least give you an idea of how these are supposed to fit together. MSO lending structures. So if you talk to most lenders, they're going to want both of the entities as borrower parties. That may or may not be permissible in some states, depending on corporate practice of medicine restrictions. But this is your basic structure that you're looking at from a lending perspective. Here are some of the things you need to think about when we talk about structuring these. And again, this is another reason why you may or may not want to do an actual MSO structure that we just described. You have to think about things like, are contracts assignable, in particular payer contracts. If you're going to be changing your practice entity or having a change of control at that level, a lot of those payer contracts may require you to give notice to the payers or get their consent before you actually engage in the transaction. So that's a big one. Also, if you need to retain the licenses or provider numbers, that can be tricky too. In particular, we've seen a lot of those are tied to the EIN of the entity. And so if you're changing the EIN for corporate or tax reasons, then that could have a ripple effect into some of these other licenses and payer agreements. Third, if there's any significant liabilities you need to try to shed, maybe they've got some old regulatory issues, or they have maybe not the cleanest track record, or just a general sense that things could have been done better. Are there reasons that you want to try to leave some of those liabilities behind? That's something to think about. Are any assets being retained? Are you spinning any assets out? Is the business being broken apart? And then last, how established is your acquiring PC? In other words, is that just a shell, or is it actually an entity that you can pick up on day one and start operating? This is you.
Yeah, great.
All right, and let me turn it over to Kayla here, who will walk us through the transaction process, and then we'll dig into some diligence questions.
Fantastic. So I know there's a number of you on the call today that have probably gone through transactions or have been the buyers in transactions. There may be a few others that are considering a transaction fairly imminently. So we've listed some of the structural elements of a transaction that we thought may be helpful for everybody. So we'll just walk through these. So the first is the pre-transaction strategy. And what I would define as this is primarily who's right for you as a partner. Would you like to do a majority sale, a minority sale? Do you want a partner that already has an existing dermatology platform? Or are you of a size of practice that you would be a great platform like Clint was talking about a few minutes ago for a particular buyer? So those are all things that happen during the pre-transaction strategy process. Then we kind of move into the transaction process, which Bart and I typically define as about 3 to 6 months before you really get undergoing in a transaction. So ideally, you would have a little bit of self-diligence and housekeeping that goes on. During a transaction, any buyer is going to do financial, operational, and regulatory diligence on dermatology practices, whether that's a strategic buyer, another physician group, or a private equity fund. So ideally, you want to know many of the things that they're likely to find in that diligence so that you can understand how to respond to it or provide the information that's necessary to answer any questions. Some ways that we recommend doing that is understanding where all your referral source contracts are, understanding any potential pitfalls you have with respect to billing and coding, and also understanding any litigation, either past or ongoing, that are currently present, because those are going to be some of the key areas that buyers really care about. And as buyers, those are things you should certainly be looking for when you do move on to doing diligence. The next item is restructuring. So Bart mentioned during the transactional talk that there's a couple of ways that this can happen. You can either do restructuring if it's needed for tax reasons or otherwise well in advance of a transaction, if you know it's going to be necessary, or you can wait until immediately prior to a transaction and then do any necessary restructuring. What we see most commonly for different restructuring processes are if an entity is organized as an S Corp or a C Corp, or if you need to move a lot of clinical or non-clinical assets around. Sometimes that will need to happen immediately pre-closing or in advance of closing generally, so that's one we always put on the list here. Then you're ready to actually go to the market. So if you're going to be going through a competitive bidding process with buyers, particularly if you're one of those larger practices like Clint was mentioning that's highly likely to demand a higher valuation, you may want to consider hiring an investment banker or someone to assist you in preparing a confidential information memorandum and connecting you with all the right potential buyers so you do have the best price possible. And then on the flip side, for buyers, they often have relationships with different of those groups so that they are able to find a lot of great target entities during this stage in the process. So when you've selected who you think is probably going to be a good fit for you, then you move on to the letter of intent stage. So the letter of intent ideally includes the key terms of the transaction. It doesn't include every small detail that you expect to happen, but it's going to cover things like the purchase price, any non-competes for your physician owners, what's going to happen to your key employees, and then sometimes if it's a particularly detailed non-compete or a particular detailed LOI, it might have the terms of those non-competes or the terms of indemnification that are going to come up in your purchase agreement. So once that's signed, and it usually gives your buyer exclusivity to open diligence process, the diligence begins, much like what I was mentioning during the self-diligence process. Buyers are going to look into regulatory, financial, and operational questions, which we'll cover a little bit later in our talk. And once that process is either ongoing or there's been some general financial diligence done, you move on to the negotiation of documents. So this is where Bart and I typically are fairly involved, and this is where you are negotiating all of the very small concepts and how everything will be covered during the transaction. And in the next slide, we'll talk about what these documents typically look like. Once everybody comes to an agreement on the documents, then you actually have the closing, where the purchase price is funded and the buyer is given access to the giving access to the business.
Kaylin, you mind if I ask two questions, actually? One, from the letter of intent portion to the closing, how long of a time period do you see that being on average? And the second question is, how often are you seeing, especially in that self-diligence phase, that sellers today are getting kind of their own audit or what we call a sell-side quality of earnings report before going to market?
Yeah, absolutely. So first, for the duration from letter of intent to closing, I think that really depends on how large your business is and how many different locations and any operational challenges that you're going to face during integration that you may want to do in advance of actually closing. But we usually see somewhere from 60 to 90 days is typical. It can be shorter, it can be longer depending on the situation, but I would say that's typical. For the quality of earnings question, I would say it's absolutely not necessary for a seller to do their own quality of earnings, but it is becoming more common, especially when you're going through one of those bid process situations to find a buyer. If you can demonstrate and know what you expect your own purchase price to be, sometimes that can give you additional ammunition during that process. Okay. So then we'll move on to the core documents. We don't need to go through each of these in detail, but we just wanted to give everyone on the phone an idea of what types of agreements are present during these transactions that will be negotiated and be important to forming the overall structure. You'll see a number of these that Bart had mentioned during his portion of the talk: the purchase agreement, the services agreement, restrictive covenant agreements, loan agreements, and there's also a transfer restriction agreement on here, which I'd like to flag is another one of those state-specific items that you really just have to look at state law to see if they're permissible in your particular state. So of those documents, these are really the key negotiating points. So Clint has already touched on purchase price, valuation, methodology, so we'll skip right over that. But then you have the question of the rollover equity and cash consideration. So as Bart mentioned, sometimes in a transaction, the physician owners will end up having equity in the management company in some way or another, and typically we see this ranging anywhere from 10% to 30% of the total consideration. So if the purchase price is $10 million, you may receive, if it's 30% rollover equity deal, 30% of that in equity in the MSO, and the remaining 70% in cash. It's also important during the negotiation to make sure you're getting the most tax advantageous structure as possible. Sometimes, for example, if you're an S corporation, this can involve things like having to do an F reorg under the tax rules. It's very important to consult both your accountants and tax counsel to ensure the structure is not going to leave either the buyer or the seller with unwanted tax consequences, and to make sure that you're appropriately complying with the tax laws when it's going to be reported. Then the next point that's an important negotiation is governance rights and operational control. So on the non-clinical portion of the business that's truly administrative, that's going to be performed by the MSO, the physician owners may want to negotiate certain control rights over employees that are non-clinical or certain types of budgeting that's non-clinical. Those are all things that happen at this process, and every buyer and seller has a different list of items that are important to them and critical for their business. That's often something during that housekeeping and pre-transaction strategy process. You as a group may want to make a list of what's absolutely critical for you, whether you're the buyer or the seller, so you're prepared for this point of the negotiation. The next is the employment compensation and terms. So nearly every situation in which a transaction happens, the physician owners of the practice continue to be employed by that practice going forward. So you are going to have a situation where you negotiate with the ongoing practice the restrictive covenants and your compensation. Like Clint mentioned, sometimes the compensation can be based on a flat salary or a percentage of net collections or your RVU calculation. It really depends on every individual transaction, but coming in, you should have an expectation of what you'd like to see so that you can negotiate at this stage. The same is true for the restrictive covenants. We typically see a restrictive covenant in the purchase agreement that governs the sale of the business. This can often be between 3 and 5 years long, and that will often be longer than any restrictive covenant that's present in the employment agreement for any physician owners going forward, which can be anywhere from a year to 2 years, and that will be a large negotiating point that will be state dependent, so you should consult employment counsel in your individual state for that. And then the last two things are related. There is the indemnification package and the escrow in the purchase agreement. So indemnification, very simply, as many people on the phone I'm sure know, is who bears the cost of a loss that occurs post-closing, but maybe as a result of something that was happening in the business pre-closing. Should that be the seller's responsibility, or should that be the buyer's responsibility? There's a variety of ways to negotiate that. Many people in healthcare transactions are seeking insurance, more often, particularly in bigger transactions, to cover those losses so that sellers don't have to worry about them down the road. But that's all something to negotiate and think about. Then we've included in greater detail in each of the subsequent slides some of the specific diligence issues for acquirers. We'll just hit these very briefly. We've included many of these in our notes so that you can go back and reference them. Bart and I are, of course, happy to talk about any of these offline if there are questions or direct you to other resources for them. So it's really important to understand the asset and collateral locations. Just like Bart said, you often have to move those around in the connection with a transaction. Clinical assets are often sold either to another practice or retained by the physician practice that's being sold. And then the non-clinical assets, if you're utilizing an MSO-PC structure, are often sold to the MSO. The restrictions on professionals, we've already talked about that. On the non-compete, are those in place currently? Do they need to be restated in connection with a transaction? That can also be very important, particularly for non-owner physicians. Payer contracts, it's always important to understand, are the payer contracts that you have assignable if you're moving them to a new practice entity, or do you want to retain the current practice entity to take advantage of any payer contracts that they may have? Then it's very important to look at each of these elements of the management services agreement or administrative services agreement. Bart covered these in some detail when talking about the structure, so we'll move past those, but please feel free to reach out if you have questions. Then it's important to understand, like I mentioned, the specific tax issues involved. There can often be hot asset implications, so it's important to consult your tax counsel or your accountants in those scenarios.
And one specific tax point to look out for that we see this all the time is C Corps and S Corps. Beware of those. Partnerships, relatively easy to transact out of. S-corps, incrementally more difficult. You can do some things and do a little bit of tax and legal ninjutsu to get you to where you need to be. C-corps, there's not a whole lot you can do with them. Those are very difficult to transact out of, so if you're talking choice of entity, definitely consult your lawyers and tax advisors before you form.
Yep. And then this last section is just a couple of other items to consider and look at. Any antitrust considerations. If you have laboratories, imaging facilities, other ancillary business lines, there are often special rules that govern those that you need to be very careful of, which are discussed on the next slide. These are often the specific fraud and abuse laws that apply to dermatology practices. You have the anti-kickback statute, the federal Stark law, which is the self-referral law, and then similar state fraud and abuse laws. Depending on how your management fee is structured, depending on where the physician owners hold different ancillary investments, those are all things that can implicate these individual statutes. You should consult legal counsel on these regulatory issues, whether you're a buyer doing due diligence or whether you're a seller considering sale. And then for your reference later, we've just listed the HIPAA compliance top 10 list that we have. These are things that are just really important from a HIPAA perspective to make sure are present. And then also the 6 best practices generally for compliance. Many of these are based on OIG compliance plan commentary. Again, happy to speak about any of those that people have more interest in. And then finally, we know some of the most important things about a transaction are making sure you have accurate and good integration practices. So here are a few things to think about, whether you're a seller after you've completed sale or buyers that frequently purchase dermatology practices. These are all items to consider. So I think that wraps us up, and we may just have a couple of questions that we have time for here.
Yeah, let's go to a couple of questions here. One is whether you see any kind of multiple variation between size of practice. I mean, Clint, that's right up your alley. I think the answer is yes, but you probably have a better answer than that.
Yes, there is, absolutely. I mean, certainly size, adjusted EBITDA margin ends up being a big driver. So the more profitable practice, that can have an impact on the multiple size. Number of providers, the balance of dermatology and medical versus cosmetic, all of those can be factors. But, I will have to say that even today, and you can use the state of Florida as an example, you've got probably, 4 or 5 private equity-backed dermatology platforms there, which means every one of those platforms are calling on and trying to complete add-on acquisitions of smaller practices in the state of Florida. So what you're all of a sudden finding is that even the smaller practices have a ton of competition for buying them, which then inevitably ends up driving up the market multiple. So it does end up being a function of the market at the end of the day.
Yep, absolutely. And we've seen also things that can affect valuation are things like enforceability and non-competes in some places, ability to prevent people from competing against you, ancillary services like surgery centers, Mohs, labs, all that stuff can impact value. How close you guys are to retirement, that's another big one. Another question about what states can you actually own a practice if you're not a physician? There's really only a handful. Arizona is one. Florida has a clinic permit you can apply for to have direct ownership. What else? Missouri. Nevada. This is just kind of off the top of our heads.
Yeah, in many situations, you actually have to register your practice with the state, get the appropriate permit. That's all really important to look at in your individual situation. And not every non-physician is even an eligible owner in those states, so it's very important to consider all of these items.
Yep. And I think we have time for maybe one more question. Have you seen a change in organizational overhead as a result of a merger or acquisition? If so, what have you seen? That's a good question, and I'm not sure if we've got insight into that. We represent a mix of companies as an ongoing concern, kind of as their general outside counsel. We represent folks during a transaction, so we see some of it post-closing, but not everything. Clint, I don't know if you got a better feel for that being on the buy and sell side of this or not.
Observationally, I mean, I do think private equity groups, when they come in and do their platform investment, and especially do the add-ons, they are looking for a way to streamline the overhead. So, that could mean finding ways where, they're able to joint use resources across the platform, and, ultimately if they can share resources and not have to keep adding overhead expense, just add to the profitability. So that's just kind of a very high level what I see. And that's back to that synergies point that we talked about earlier.
Yeah, I think it's they're voracious cost cutters, but not at the risk of cutting corners. I think you have to be very careful that you're not taking things away from the physicians that they need to practice effectively. And I've certainly not seen that at all. The types of cost savings that I've seen have been from aggregating employee benefits, from purchasing in bulk, just cost of capital and debt costs, and layering that onto the organization, getting administration in order, billing and coding costs and personnel, IT, streamlining processes, operational efficiencies. Those are the kind of things I really see from sophisticated managers who are investing in these things. But again, that's kind of our view of it. We got a couple other questions. I think one or two of them are a little bit too, I think, in depth to really fully respond to in this setting. But what we can do is we'll certainly reach out after the webinar, and I think that goes for everyone. Is if anybody would like to speak with us off the clock, I know we're more than happy to do so. I'm sure Clint would be happy to talk to you. If you're looking at a deal, if you're considering a deal, if you just want to know more about the sector, we're happy to spend some time on the phone with you. We spend a lot of free time on the phone just meeting people and building relationships, and that's one of the ways we do it. So we'd be happy to talk to you. And we will circulate copies of the slides after the fact. That would be helpful to folks. And then finally, there is a webinar recording available if you would like to listen to it again or pass it along. We'd be happy to have you do that. So thanks again on behalf of all our speakers. We appreciate everyone joining. And don't be a stranger. Feel free to reach out. And thank you. Have a good rest of the day.